This is the Asset Protection Show. Expert strategies by attorney John Skabelund.
Welcome to the Asset Protection Show, the podcast dedicated to not only protecting your assets from lawsuits and creditors, but also to protect your legacy. After all, what we do isn't just for ourselves, it's to create generational wealth. I'm your host, attorney John Skabelund. Nobody wants to get sued. Today, we'll discuss the most important strategy to avoid being sued. Let me start by sharing a story. A couple of years ago, my family and I had a wonderful time in Whistler, British Columbia. While we were visiting Whistler, we also visited Vancouver. We took a guided tour, and our tour guide shared an interesting fact. The tour guide said, no one knows who owns more than 50% of the properties inside the city. Now, he acted like this was a terrible thing. On the other hand, as an asset protection attorney, I said, spot on. That is exactly how it should be. Unfortunately, accidents happen. They happen to all of us. This is why we call them accidents, not on purposes to begin with. Furthermore, accidents aren't predictable. There's no way to plan for them. No one can get through life without accidents, it seems. Now, when an accident occurs, the goal is to settle for insurance policies and move on, to not even be sued in the very first place. A couple examples. A client of mine unfortunately had an investment rental property burned down. The smoke alarms did not go off as properly. Now, unfortunately, someone died in that terrible accident. As you can imagine, the lawsuit would have been staggering. Another example is a client whose teenage driver accidentally killed someone while driving. Now, what I'm saying is that I allow my clients or enable my clients never to pay out. That's why insurance is always an important part of our asset protection strategy. But the point is this, I don't want my clients to even be sued. The goal is to avoid the lawsuit by incentivizing settlement and avoid the lawsuit from even being filed to begin with. The reason why in these particular instances a lawsuit wasn't even filed is the fact that my clients looked broke. In my career as a litigator, I have explained to clients, look, you have a great case as far as the facts are concerned and the law. However, after I've done a search for the assets on our defendant, I need you to understand you could be throwing good money after bad because they look broke. Although you may win the lawsuit, you may ultimately lose because there's nothing to take from the defendant. So how do we accomplish that? We want to make the client look broke. And we do that by legally hiding their assets. So what assets can be discovered by a plaintiff attorney? Well, first and foremost is real estate. Your residence, your vacation home, your investment properties. Second are your businesses, whether it's an LLC, limited partnership, or corporation. And then next are anything with a vehicle title. That could be an RV, an exotic car, could be a boat, plane, anything like that that has to be registered. Now notice which assets I didn't say are discoverable. So your bank account, your brokerage account, your crypto, your art, your jewelry, your collections. These things are already private. And in fact, your W-2 wages are private as well. You may be asking yourself, just like many of my clients do, isn't it possible, John, to be able to discover these assets if you sue someone? And that is the important part. It's all about timing. The discovery before filing the lawsuit versus discovery after you've won a lawsuit. Prior to suing someone, we can do a search as attorneys for real estate, businesses, and vehicle titles. That is pretty easy to do. There's services like LexisNexis, Westlaw, TLO from TransUnion. There's private investigators. We all use databases because these are publicly available records, and these companies provide this information to plaintiff attorneys. However, that search is performed prior to the lawsuit to determine whether it makes sense to even sue someone. Again, the goal being that they are only interested in settling for the insurance money. Again, I can't emphasize enough, everything we do is legal and ethical. It's ethical because we provide very good liability insurance to pay out when accidents do happen. However, the point of hiding your assets is simply this. In order for them to discover what you own, it would have to be post-judgment, meaning they have already sued you, they've won their lawsuit, which, by the way, typically takes more than a year or longer. So that is a long time for someone to win. It's also an investment. Many times you're looking at $50,000, $100,000, $150,000 in attorney's fees to defend someone. So it's a large investment on the unknown. Now, once they have what we call a judgment, that is what a judge grants a plaintiff if they've won their lawsuit. They can subject you to what's called a debtor exam. That debtor exam means that under oath, you must disclose what you own. But here's the difference. Very big difference to disclose what you own when you own an interest in an LLC, limited partnership, beneficiary interest in the irrevocable trust, versus having to list detailed assets such as real estate, businesses, brokerage accounts, vehicle titles, things like that. So we can hide even ownership of specific assets inside tools like LLCs, limited partnerships, and irrevocable trusts. Again, if you're not in charge, which can be arranged, you may not have to disclose what that business entity particularly owns. You may be wondering, how do we legally hide your assets? We have many tools as experienced asset protection attorneys. Experienced attorneys who specialize in asset protection have many tools available to us. LLCs, obviously, in privacy states. What are those states? You probably have already heard of them. Delaware, Wyoming, Nevada to a degree, Ohio, New Mexico, Oklahoma. There's a handful of states in the country that do not disclose who the owner of the LLC is or who manages it. By the way, that's why I don't prefer Nevada LLCs. Nevada does disclose the manager of the LLC. It doesn't take a rocket scientist, let alone a plaintiff attorney, to realize that if you manage a Nevada LLC, you likely own that LLC. So complete protection will hide both who the owner is and who the manager of that LLC is. And by the way, you always want to have a manager-managed LLC for asset protection. But that's a topic for a different discussion. Other tools that an asset protection attorney can utilize are irrevocable trusts and limited partnerships. Thank you for joining me today as we discuss why privacy is important to asset protection.
You've been listening to the Asset Protection Show, expert strategies by attorney John Skabelund. For more information, go to assetprotectionshow.com.
This content is legal information only and not legal advice. Viewing this content does not create an attorney-client relationship. Mr. Skabelund is admitted to practice law in Arizona, and he may be reached at ultimateassetprotection.com.